time in the context, I said of the context of the right of the terrorist suspect. Actually, when you say terrorist suspect, I think one should maybe make it a bit broader than that and say in the context of people whom a state feels may not be entirely desirable to have around. Because some of what I'm going to talk about later, in particular, the role of the special advocate and the operation of what's called SIAC, the Special Immigration Appeal Commissioners in the UK, that actually arose in the context of ordinary, quotes, ordinary immigration law in the United Kingdom. But before I get into the subject, I want, you're now used to this tradition, my way of teaching, I want to try to explore with you some of the elements that are going to go into this story. And I gave you a bit of a hint by saying on the handout that there are some distinctions that you might want to draw between internal security within a single state, security within the EU as a bloc, and then international security. Now, why might I have been suggesting to you that those would be distinctions that you might want to think of drawing?
Alors, you know how it works, so
it's as usual. J'ai une feuille vierge, hein, comme toujours, hein, je ne triche pas. J'ai une feuille vierge, alors j'attends avec impatience vos suggestions.
Et je pense qu'il y a peut-être des étudiants du master de spécialisation en droit européen qui nous ont rejoints, qui n'ont peut-être pas suivi toutes les autres séances. Mais donc, pour les mettre à l'aise, vous pouvez intervenir en anglais ou en français. Et l'idée n'est pas qu'il y a une seule réponse correcte, c'est de réfléchir ensemble. Donc, vous ne devez pas être inquiet de prendre la parole. Et surtout, vous devez prendre la parole parce que sinon, il n'y aura pas de cours aujourd'hui. Et vous pouvez introduire aussi des propositions sur le chat, mais c'est encore mieux si vous levez la main.
Et aussi, dites-moi, s'il vous plaît, dites-moi qui vous êtes, tout simplement. Hein.
Oui, voilà. Oui, pardon. On avait dit ça. Alors. Oups.
Allez, soyez courageux. Je vous promets que je n'ai...
Sébastien Willems, ça vient de se désigner.
Très bien.
Sébastien, vous avez la parole.
Hello, Sébastien. Oui, bonjour.
We don't hear.
Hi,
Voilà.
My name is Sebastian Willems. I'm a student in the second year master law program in the ULB. So, in my opinion, we definitely have to take into consideration the fact that in the EU law, we have to differentiate intra-EU security and I would say security of the Schengen area as a whole. That is, for me, the first distinction is, for example, the situation where within the Schengen Accords, we will have more protection on the borders outside of the EU's member states who are part of the Schengen Accords, whereas the intra-borders, the borders within the Schengen area, will be less important. For example, in the migration law and also the asylum system that we've seen last week, we can also take into consideration the fact that the borders will be more present on the border that are close from the areas where the migrants come from. That is a very important distinction to make in regards to the inter-borders, which have been in a certain way dissolved, even also in regards to migration between different member states.
Mm-hmm. Thank you. That's helpful. Somebody else, please.
So I'm looking at the hands raised. Allez, ne soyez pas timide. Que vous inspirent ces distinctions ou potentielles distinctions entre les différents types de sécurité? Sinon, je vais désigner. Hein. Je vais vous faire peur. Clélie, Simoni, vous n'avez pas d'idée? Ou Eva Bodichot?
Attendez, allez-y.
Voilà, Clélie, je vois, Clélie.
Non, mais je suis assez d'accord avec ce que disait Sébastien sur l'importance dans le cadre de Schengen de distinguer du coup entre ce que les États membres peuvent faire au niveau de leurs frontières nationales. Et pour ajouter, je crois, une information à ce qu'il disait, dans le cadre de Schengen, les États membres ont toujours la possibilité de réintroduire des frontières, notamment dans le cadre de risques. Et on l'a vu, je sais que dans le cadre de la France, ça a été utilisé notamment au moment des attentats terroristes de 2015. Et donc, effectivement, cette distinction me paraissait assez pertinente entre ce qui peut être fait à l'échelle de l'Union et ce qui est fait à l'échelle d'un État membre. Voilà.
Merci beaucoup.
Intervention qui est aussi utile. Let me try to help you all along the road a little bit to be a bit more friendly. Let's talk about just one state, all right, to start with. From the two helpful contributions that have been given already, we're going to, I think, say already how much you have control over your external borders is going to depend whether you're inside Schengen or out of Schengen. For a country that's within Schengen, in principle, via the other Schengen countries, you're not meant to be checking at the border, right? But you do have a shared Schengen information system. There are tools which enable the Schengen member states to inform each other of potential problems. So on the one hand, you don't stop everyone at the frontier, but on the other hand, you do have access to a lot of shared electronic information, right? And as you have just said clearly, if you also have the possibility in a situation where there's a real threat of reintroducing border controls, and we did indeed see that with France in 2015. If you're not a Schengen state, then you have greater degree of control at the border, but you still don't have that much control. You're meant to let other EU citizens come through with really minimum controls. You can be tougher with third country nationals, but of course you do have a common visa system. In other words, there are already some common rules in place. Even if you're a non-Schengen state, there are EU rules. So to some extent, what happens on security is an EU matter. And I'm just going to drop into there without going there in detail, the whole word of competence, right? What is EU competence? What is member state competence? The fact that that is a boundary, which is something that everyone cares about. If you're a member state, you don't want the EU doing things that still belong to you. On the other hand, you do want coordination at EU level because there may be problems that are much bigger than your borders. What about what you can do inside your own country? We haven't really thought of what can you do within your own state?
Qui souhaite prendre? Oui, Sébastien Willems.
Thank you. Well, I guess it would depend whether you're you're a member state which is inside the Schengen area or does share a border that is close to the outside of the Schengen area. Let me explain. for example, as Belgium now, we have a frontier. Well, no, let's take another example. For example, for I would say Croatia, who has borders who don't with a state who is not part of the EU.
Mm-hmm.
The responsibility of the state will be in a certain way would be more important in regards to the fact that the border of the Schengen area being close to outside of the EU, the state will have more I would say responsibilities regarding the entry of people inside the territory, since when the people are inside the territory, the fact that the people can move without any borders within the EU makes it then easier for these people to come and go to France when they're inside. So in my opinion, a member state, it depends really on which member states we're talking about.
I agree with you completely that if you are a member state which is part of Schengen and which has an external border with a third country, the rest of the Schengen area is going to kind of look at you and say, you better keep that border safe. I agree with you completely, right? Totally. I was actually thinking more about things that you can do within your own country as a sovereign state in order to look after your own people. And I mean, I'm going to move this along by starting to give you some of the things I'm thinking of. For example, you can require foreigners to go and register with the police. You can require everyone to be registered with the commune. Both of these, by the way, in the United Kingdom, you would just look at me if I said this to you, because there is no such system. And indeed, that became very apparent with Brexit, because the UK had actually no idea how many EU nationals there were inside the UK, because there is no such registration system. And, you know, there was a guess that maybe it's 3 million people. And actually, if you look at how many people have been applying for settled status, it looks as though that was a real underestimate, and maybe it's 4.5 million. But, you know, literally, they didn't have any idea of how many foreigners they had inside the country. All right. Now, if you are used to the Belgian system or here in Luxembourg, obviously, you know, you're registered with the commune as living where you live. I'm registered with my commune. I was registered when I was a foreigner. I'm still registered now. I'm a Luxembourger, right? And then also within a country, there's a degree of internal security. So there is a security service which does surveillance, which if it learns that there is somebody suspect who's in the country, they then put them under surveillance. There may be systems for giving authority to tap phones, to check things. All right. In other words, there is usually some type of a state service that helps to try to keep people safe, and which in that context gathers material. Okay. Then you have everything that's happening at the EU level, but then also you have an international level, and the international level is an international level. I'm going to quote to you from the basic UN Security Council resolution in 2001, resolution 1373 of 2001, that laid out sound, please, if you will, and if we have the same problem again, we'll try applying the same solution. So at UN level, the highest level you can have, we have a UN instruction saying we need to combat terrorism and we need to combat the financing of terrorism. And the reason why we have this is also that in terms of our thinking about what we do with people we don't like, we have moved from a situation in the past, if we didn't like a regime or a country, we imposed sanctions on that country. So, for example, when we didn't like South Africa and apartheid, we imposed sanctions on South Africa. We imposed sanctions on Rhodesia. We then noticed there was a problem. The problem was those sanctions did not hit the right people. Usually, the effect of those sanctions was to make life utterly miserable for the ordinary poor people in that country. Sometimes, indeed, the very people on whose behalf, as it were, we were acting. If you look at South Africa and Rhodesia and apartheid and the effect of the sanctions was actually to hurt the black population. And it hurt the black population much more than it hurt the Boers in South Africa. The white population didn't like the sanctions, but they were more okay. The people who were really badly hit were the black population, and that was the last thing we wanted. So then we got onto the idea of what became called smart sanctions, where you say, okay, no, we're going to do it in a more surgical way, like a doctor with their scalpel, yeah, more surgical, and we are going to apply sanctions so that they hurt the people they should hurt, so that they are targeted. And the UN resolution I've just quoted to you as an example of an instruction to take targeted sanctions, to focus on people who are going to provide, who are going to be involved in terrorism, who are going to facilitate terrorism, who are going to be acting on behalf of or at the direction of terrorists. So very, in theory, very focused, and those are the people whose financial assets, whose funds, whose economic resources we're going to target. So far, so good. But when you move from the old-fashioned sanction to the smart sanction, you get some rule of law issues, because now you have individual people and individual entities with rights to be treated fairly, because here are some basic rule of law principles. And so they have rights to know what the case against them is, and they have rights to contest rules that freeze their assets. So there's a big shift. It's a good idea to have smart sanctions, but there's a revers de la médaille. There's a reverse of the coin, you say in English. The reverse of the coin, the other side of the coin, is you're going to get individual rights involved here. And you are going to have, as you get individual rights involved, you are going to find yourself striking a balance. Because on the one hand, you want to know, you want to go on being able to run your intelligence service and your surveillance service. And you want them to have operational efficiency. You want them to go on working. On the other hand, you have to have rights of the defense for the people who are the target of your smart sanctions. And these two aims may fight each other. Another distinction that I want to try to draw for you, because it's important, is, and I put it under little b in my handout, I said, look, the security surveillance, then there are security decisions, and then there are court cases. Let me try to explain that to you in a fairly short way. And I should begin this by saying, a little my own background. I actually did, on behalf of the UK, inside the UK, I did some cases involving classified material and security cases, all right? And so I discovered a little bit, I was totally innocent about this before, but I discovered a little bit from the inside through doing that work as a barrister. I'm also going to be careful not to tell you any actual detail of work that I worked on, because, of what I actually looked at, if it isn't public domain, because I need to be careful in relation to my past. If you are finding out information about a suspect, first of all, you have something that needs to tell you this person may be a bad person. And that may be a little tiny piece of information like that. Then you build up a security picture of the person. And that picture is built up. It's like a mosaic. It's lots of tiny, tiny little bits of information which are analyzed by people who have a lot of experience in the area, and they start to kind of get a bad feeling about this person. They say, look, you know, the patterns of what we're seeing, the people they're meeting, and then you have little bits of information from telephone taps. And you have, it's really like a mosaic. And you put it together, and as you put it together, you really start to be more and more convinced that you should be watching this person. And so you put in place various additional measures. Some of them you have to ask for permission to do a telephone tap, for example, a telephone recording. You have to have permission for that. You might put surveillance outside their building. You might have someone who watches, and if they come out, they follow discreetly, and you see who they meet and so on. Now, all the people who are working in the field are actually running a risk, because they're out there and they're dealing with people who do not think that they have to play by the same rules of the democratic society. Sometimes they may be your agent in the field, may be pretending they're a member of the group, or at least that they're a sympathizer for the group. So they may be going along to meetings that the group is having and saying, yes, yes, you know, and then looking around, okay, who else is here? The people who are working in the field are running sometimes very big risks, and they are reporting back, but protecting their identity and protecting them from being uncovered is extremely important. Because, to be really brutal about it, if you get it wrong and you allow their identity to be discovered, they may end up with their head cut off in a ditch. This is not, you know, this is people not playing games at all. This is a deadly serious business. And so it really does matter from a security point of view that certain material stays classified. Now, when you're doing the security surveillance, you don't yet have a case that would be anything like strong enough to stand up in court. You just have little elements which make you think there's a problem. When you take a security decision, you have more elements, but maybe still not what would be right in court. But as soon as you say rights of the defense, you are saying that the person who is the subject of that decision has to be able to challenge the material that was the basis for the decision that affected them adversely. And so at that stage, you have to be looking at it through the eyes of a lawyer who will have to defend this in court. And you have to be saying to yourself, is this material that we've got adequate to explain why we took the decision we took? Doesn't have to be perfect. The court will give us some margin, right? But it does have to be stronger, significantly stronger than at the beginning when you had security surveillance. So I'm going to suggest to you there's a kind of stream, okay? At the beginning, there is the security surveillance, which is all these little elements. Then there's enough to take a decision. And then there's the, can we defend that decision in court? And of course, when you're defending it in court, there is the question of what is going to be shown to the attacker, to the person challenging the decision. But also, let's go back to what we were looking at before, the state, the EU, the UN. There's the big question of what information we're sharing With whom? Are we giving all our security material to our EU partners? Are we giving them the raw material? No, of course we're not. Are we giving them edited material that tells them, for these reasons, we think that? Exactly how is that working? Because the EU decision is going to be based on the material that's available to the EU decision maker. This is a very complicated intermeshing system, which really raises some interesting questions of rule of law. Because if you want to uphold the rule of law, it has to be possible to challenge. It has to be possible to say, look, you know, you got the wrong guy. I know my name is Abdul, but I'm not that Abdul. I just happen to be called Abdul. And I'm nothing to do with the Abdul you think I am. I'm actually, you know, I'm a grocer and I work in Stockport, and I'm not that Abdul. You've just got the wrong guy. Or you have to be able to say, yes, I know that my organization in the past was involved in activity involving violence, but actually we're not anymore. And so, you know, we've given up violence. And so you should not go on punishing us because we are no longer violent. So we should no longer be on a list. And that involves you being able to challenge. You can't, you know, you must have a machinery for challenge, and the machinery must allow you to make the challenge and to make a valid challenge. Now, I cannot conceivably do justice to the cases that I put down. I put 4 cases down on the list, really to draw your attention to the kind of the issues that are involved. The Cardi 1 case is incredibly well known, all right? And because when it came through, there were vast debates about the situation under the rule of law. Surely, if the UN has an instruction to do something, and all the member states are members of the UN, if the UN tells you to do something, surely you should do it. And that's what the General Court thought in Cardi 1, and they dismissed Mr. Cardi's challenge, because he'd been put on a list. And the Court of Justice said, no, 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 we have rule of law within the regional bloc, which is the EU. I think it's important to, the easiest place to take a summary of Cardi 1 from is actually from Cardi 2, because the court found itself having to summarize what had happened in the first Cardi case in order to explain what it was then happening in Cardi 2. So we have Mr. Cardi, who is identified as being an individual associated with Osama bin Laden and the Al-Qaeda network. The Sanctions Committee lists his name, and then he is put onto the list in the annex to a council regulation. There's a freezing of funds and financial resources in relation to the Taliban of Afghanistan. He challenges before the General Court the regulations doing this. And the General Court dismisses the action, and they say it follows from the principles governing the relationship between the international legal order under the UN and the European Union legal order that you can't do a judicial review of the lawfulness of the EU regulation. That regulation, the General Court thought, enjoys immunity from jurisdiction. Essentially, you can't review the rights of Mr. Cardi vis-a-vis that regulation. I should point out, because it's important, that there was no body at UN level that Mr. Cardi could go to. The only thing that could happen at UN level would have been that a UN member state could have said to the Security Council, look, we don't think this guy's name should be on the list. But that's not individual protection of individual rights, is it? If you want protection of individual rights, you have to have the individual with a right of challenge. So the General Court said, we see there's a problem and there's a lacuna in judicial protection, but the lacuna isn't contrary to US Kogan, so it's not a problem. Mr. Cardi appeals to the Court of Justice, and the court says, we're setting aside the judgment of the General Court, and we annul the regulation 881/2002, insofar as it concerns Mr. Cardi. And it's a big constitutional law judgment, because the court says the obligations imposed by an international agreement cannot have the effect of prejudicing the constitutional principles of the EC Treaty. Those constitutional principles include the principle that all European Union acts must respect fundamental rights. That respect is a condition of the lawfulness of the act, and so the court has to be able to review that. So there's a complete system of legal remedies. And so even if this EU Act is implementing Security Council decisions, that doesn't make it immune from review. And so we have to ensure the review, in principle, the full review of the lawfulness of all European Union acts in the light of fundamental rights, including where those acts implement Security Council resolutions. If you want to note, that's at paragraphs 326 and 327 of the judgment in Cardi 1. Cardi 1 is a very long judgment, all right? But it does repay reading, because you have to see how the court gets itself to saying, even though this is a UN resolution, we still have to patrol the rule of law within the European Union. We can't have a situation where within the European Union there are acts that are immune. And so if you are going to have review, what does that mean? Paragraphs 336 to 341 of the Cardi 1 judgment, what that means is that the effectiveness of judicial review means that the competent EU authority has to give the grounds for the contested listing to the person concerned. And it has to give the person concerned with the opportunity to be heard. If you're talking about a first decision to put somebody on the list, okay, you may need to act quickly. You may need to act, as it were, with secrecy in order to be able to freeze funds. You can see if you told them everything in advance, the funds might no longer be there by the time the measure came into effect, right? So for a first listing decision, the disclosure and the hearing don't happen before the decision is adopted, but they must happen as swiftly as possible after the decision is adopted. So the decision comes in, it has the surprise effect, it freezes the funds, but you must then make available the review process. And in Cardi 1, the court says that was 336 to 341 of Cardi 1, and in 345 to 349 of Cardi 1, the court goes on and says, look, you know, the council didn't give Mr. Cardi the evidence against him, and they didn't give him the right to be informed of the evidence. He couldn't make his point of view known. He had no rights of the defense. He had no effective judicial review. This isn't good enough. So they concluded, 369 to 371 of the judgment, they concluded that his fundamental right to respect for his property had been infringed because he'd had no right to the defense. So That is Cardi 1. Big judgment. Big rule of law judgment. Lovely opinion, by the way, by my former colleague, Miguel Puech Maduro, Advocate General Puech Maduro, which has got the statues of the gods being occasionally veiled. It's a very poetic opinion. So, I am going, before I go across to Cardi 2, which leads to the new arrangements in front of the General Court, I'm going to speak briefly about two cases, PMOI and the Hamas case. The PM, I warn you, both of them are cases where I wrote opinions, all right? For that reason, I am going to apply a self-denying ordinance, and I am not going to refer to my opinion, all right? Because if you want to read what I said, you can read what I said. I am going to tell you very briefly what was going on and what the court found itself doing. The situation in PMOI, which is case C2709P. This involves the PMOI is the People's Mujahideen Organization of Iran, PMOI. And the situation was so wildly complicated that I ended up, at the end of my opinion, there is a chronology, because otherwise it is almost impossible to understand what was going on and what was going on when. I make a little comment to you in passing here. It's part of my training as a barrister in the UK. I was taught when I was training for the bar, I was taught that the single most useful document that any lawyer can write when they are preparing a case is to prepare a chronology. And that was very good advice, because dates don't lie. If something happened before something else, there may be causation. If something happened after something else, there cannot be causation. And if you have a conflict, this is just a little piece of advice for any of you who may be thinking of going into practice, learn to make chronologies, because they really will help you in understanding what's going on, and they will save you from making submissions to a court which cannot conceivably be correct. At the end of the PMOI opinion, there is therefore a chronology, picking out the most important things that happened in that chronology. In 1997, the US Secretary of State designated the PMOI as a foreign terrorist organization. They were engaged in acts of terrorism according to the US. In 2001, the UK Secretary of State for the Home Department made an order, the effect of which was to designate PMOI as a prescribed terrorist organization in the UK. And that order is a sufficient basis for having EU measures against the PMOI. We have a member state saying, they are terrorists. And that is an adequate basis to do something at EU level. There was then a judicial inquiry, that's March of 2001, and in April 2001, you get a judicial inquiry into the activities of alleged members of the PMOI that opens in France. All right. Then we get the UN Security Council resolution I mentioned to you in September 2001, resolution 1373/2001. And then we get the council in the EU starting to adopt, and there's always a pair of decisions. There's a common position, and then there is actually a decision imposing the freeze. Initially, the PMOI's name isn't on the list set out in the annexes. but it is by May 2002. And you have activity happening in the French Republic, people raiding offices and so on. You have the PMOI bringing an action before the General Court, and they get a win in the General Court. They get a partial annulment of a decision, but then the Council adopts a new decision, and PMOI's name is still on the list. But then in 2007 in the UK, you have a decision by a body called POAC, the Prescribed Organisations Appeal Committee, POAC, P-O-A-C. And they allow PMOI's challenge to a decision by the Home Secretary in the UK. The Home Secretary has refused to lift the order saying PMOI is a prescribed organisation. And PMOI challenged that, and POAC allowed the challenge. They say the Home Secretary should have lifted the order. The Home Secretary appeals, and the Court of Appeal throws out the appeal. They were actually very rude about the Home Secretary. If you want to enjoy this, read my opinion. The Home Secretary took a deep breath and therefore did what they had to do. By now we're 2008, right? The Home Secretary takes PMOI's name off the list of prescribed organisations. So the UK basis for the EU measure disappears. But the French Republic provides some material to the EU, and on the basis of the French material, PMOI's name goes back on the list, right? I give you this narrative so you can see just how complicated this is, right? And also you can see that there is an interaction between what's happening in the member state and rule of law in the member state, so the challenges in the member state, and then what's happening at the EU level, because the EU material is built on top of what can be done in the member state. And that is where you get the action then coming at the EU level. You get the challenge to what has now been done on the basis of the material hastily supplied by France, and the General Court upholds PMOI's action. And then you get the challenge in the Court of Justice. The French Republic brings the appeal and says, hang on a minute, surely the General Court got this wrong. They were wrong to uphold the action for annulment. This is all terrible, right? And in that case, I'm happy to tell you, I'm happy because it was the way round that I did it, right, as the AG. I'm happy to say that the Court of Justice felt that there was a problem because the PMOI had not been given the new material on the file and given an opportunity to make known its views. The General Court had found that, and the Court of Justice said the General Court got this right. The General Court had said you had to allow the fundamental importance to observance of the rights of the defence, and the Council hadn't established that it was so urgent to adopt the new decision that it was impossible to let the PMOI know this new evidence and to give them a chance to be heard. France had said that, you have to get on with it, you have to get on, you must do it immediately. And neither the General Court nor the Court of Justice bought that argument. So the appeal was in fact the appeal by the French Republic was dismissed. Right? The Hamas case, which is case 7915, is, I'm going to have to abbreviate this because otherwise we can't possibly stay within what we're trying to do. Hamas is maybe not entirely my favorite organization, but that doesn't mean that they don't have rights to the defense. Here we have a relisting issue because we have a first listing and then there's renewed listing. And the question is really, how much information do you have to have in assessing whether a body or an entity should stay on the list? You have a first listing, but then every 6 months these regulations run out, and so there is then a relisting. Now, when you relist, how hard do you have to look? I give you the Hamas case. There's also a case about the Tamil Tigers. You know, there are a number of these cases, and I'm trying to give you a flavor for what's going on, because you see, you've got the EU dependent on what's happening in the member states, but the EU can't say to the member states, you have to take a new decision every 6 months. So what material does the EU have, and how much does it have to be new material, and how much does the material have to be material that's in the public domain, or is it secret material? Can you rely on old material? You know, where are the boundaries on this? How far does the right of the defense go? The essential elements of this is the second part of the first ground of appeal. I should add that all of these, I think, always you have got multiple grounds of appeal, and the grounds of appeal are always divided into several parts, okay? The bit you actually need in the judgment is the bit that is between paragraphs 35 to 54, which is the discussion of the second part of the first ground of appeal. The council is here saying the General Court was wrong in saying that the council had to rely exclusively on material in the national decisions of the competent authorities, and that the council couldn't rely on information obtained from the press and the internet, because the council had kind of fed everything into there in order to try to keep Hamas on the list. And the analysis of the Court of Justice is to say, look, when we have a renewal decision retaining a person or entity on the fund freezing list, that is an extension of the original listing. So it presupposes there is an ongoing risk. When you have an ongoing risk, you don't actually require there to be new material, you just require there to be an ongoing risk. Member states are obviously meant to tell the council if there are new decisions and so on, but there isn't actually a mechanism that enables the council to be provided automatically every 6 months with national decisions that are adopted after the initial listing. You have protection for the initial listing. You do have protection also in relation to subsequent listings, because you can bring a challenge before the courts of the union, and you can check, was the obligation to state reasons complied with, and are the reasons sufficiently detailed and specific, and are the reasons substantiated? And so that's the basis on which you can challenge, and that's the parameters for your challenge. But there is actually no requirement in there that you can only rely, the EU authorities can only rely on material from national decisions. The rules don't say that. You can rely on other material too. And the court felt that the General Court had simply gone down the wrong road by saying you can't rely on material from the press and internet. Therefore, because you relied on that, you erred in law. The Court of Justice says you can rely on material that's press and internet as well as on national material. So therefore, in saying you can't rely on that, obviously the General Court was wrong. Therefore, the General Court decision is wrong. The court then sent the case back to the General Court, and there is a further case which is T400/10 renvoi, and the General Court decided that, and then it came up to, I mean, you know, you can follow this one through if you want to, but my purpose in showing it to you was in showing you how difficult this is trying to work out what you're doing. I need to mention very briefly before we have our break, I need to mention Cardi 2, because the Cardi 2 judgment, this is joint cases C58410 and others, right? It's the Cardi 2 judgment which requires you to sort out how do we do extent of the rights of the defence, how do we do effective judicial protection. And the passages that you need in particular, it's a very, very lengthy judgment. As a result of Cardi 2, the court and the General Court decided that in order to be able to give the people who would be challenging these listing decisions adequate material for them to exercise their rights to defence, there had to be a new provision in the rules of procedure for dealing with closed material, for material that was sensitive, confidential security material, which would somehow manage to balance the rights of the defence with the need to protect sources. And having balanced that in midair, I am now going to suggest that we take our 10-minute break now. And when we come back, we will look at Article 105 of the Rules of Procedure, which I put in my handout, so you have the text. And we will also look at the special advocate situation briefly in the UK by way of comparison. OK? Donc, on fait une petite pause, Emmanuel, à ce stade.
Thank you very much. Merci beaucoup. Donc, dans 10 minutes, on se retrouve à 17h12 pour la suite. Merci beaucoup. Ouais. Parfait.
Ça va, nous avons de nouveau.
Donc, les étudiants et étudiantes sont présents. Et donc, si l'un ou l'autre veut...
C'est bon. Alors, c'est très bien. C'est même magnifique. So, let me go back very briefly to Cardi 2, because Cardi 2 is the basis for what the Court Rules of Procedure Committee then did with Article 105 of the General Court's Rules of Procedure. And as I said, Cardi 2 is a long judgment, but the bit that you need to have a look at if you're going to understand Article 102 of the Rules of Procedure properly is the passage between paragraphs 111 to 134 of the judgment. And I'm going very, very quickly to paraphrase that. So the court begins by explaining how important the rights of the defence are. This is a bit like saying motherhood and apple pie are both important. And it says the individual must be in a position where they can make their views known, and they have to also, if there's been any exculpatory evidence submitted to the authorities, they have to take that into account. So far, so good. The statement of reason must identify the individual, specific and concrete reasons why the competent authorities consider that the individual concerned must be subject to restrictive measures. That's the test. That's what the statement of reasons has to do. So then we get court proceedings, and the courts of the Union have to determine whether the procedural safeguards have been complied with, but they also have to check whether the decision was taken on a sufficiently solid factual basis. And that can't be a review in the abstract of whether the reasons are cogent.
Eleanor, je pense qu'on ne vous entend plus de nouveau.
Est-ce qu'on a de nouveau des problèmes là?
Oui, est-ce que je vous réinvite?
Oui, oui, s'il vous plaît. Je quitte, vous me réinvitez.
Parfait.
Et je débloque mon micro. Est-ce que ça va?
Ça va, oui, parfait.
Ah, OK. Que les dieux soient avec nous cette fois-ci, hein, espérons-le. All right, so the courts have to make sure that whether this is substantiated on actual facts. Then the court accepts that, all right, there may be a problem. It's paragraph 125. Overriding considerations to do with the security of the European Union or the member states may preclude the disclosure of some information or some evidence. So we need to find, as the court so beautifully says, we need to find, I quote, techniques which accommodate, on the one hand, legitimate security considerations about the nature and sources of information, and on the other hand, the need sufficiently to guarantee to an individual respect for his procedural rights. So we need techniques. And the court goes on to give a bit of guidance as to what those techniques should consist of. Maybe there's some summarizing, but it was clear that something needed to be put in place. The court has just said we need techniques, and there were no techniques. Into the Rules of Procedure Committee of the court, on which your humble servant had the honor of serving. And we were essentially told, you need to come up with some techniques. So we tried to come up with some techniques. And the result of that is what you see in Article 105 of the Court's Rules of Procedure. Article 105 was much fought over and was, like many texts, is a compromise text. I don't know, I'm going to ask the open question, have people looked at Article 105 at all? I put it into the handout to give you a chance to look at it, but have you actually looked at it? I'm not writing down names, I just want to know, how much I can assume you've looked at it and whether you haven't had time to look at it.
Vous pouvez peut-être lever votre main si vous avez pu lire l'article en question, la main sur Teams. Au-dessus, le petit bonhomme avec sa main sur la... Ou dire tout simplement oui ou non.
Tout simplement pour que je sache, hein, c'est pas pour vous pénaliser. C'est pour voir comment je dois attribuer ce qui me reste pour le temps pour mon discours, comment j'équilibre entre l'analyse de l'article 105 d'une part ou le système du SIAC de l'autre part.
Donc, ce que j'ai transmis ou normalement Louise Fromont vous a transmis vendredi, est-ce que vous avez eu l'occasion? Donc là, il y a une réaction disant non, sorry, de la part de Sébastien Willems.
Bon, écoutez, merci de votre honnêteté. I'm going to do this. I'm going to have to do this quickly. Please go back and look at it, thinking about rule of law. All right. So the way we've set this out in the rules of procedure is, first of all, if you've got a party, for that, understand the council, right? If they're going to be defending themselves on the basis that they've got information, but that giving that information to the applicant is going to damage security, the information is produced in a separate document. So it's not in the main pleading, it's in a separate document. And it's accompanied by an application for confidential treatment. And in the application, you say why, you give the overriding reasons which, to the extent strictly required by the exigencies of the situation, justify the confidentiality and which show why you shouldn't give it to the applicant. So, main document, defense, separate document, confidential material, and separate application for confidentiality and explaining why. And you're meant to explain, you're not meant to claim confidentiality for everything. You're meant to explain to the extent strictly necessary why material has to be confidential. Also, by the way, the General Court itself can request this information. When this information is put in, naturally, it is not given immediately to the applicant because the General Court has got to decide what to do with it. If the General Court decides this information is relevant and we don't think it should be confidential, then the General Court says to the party that produced it, will you authorize its communication? If the party objects to it being communicated or fails to reply, the information is put to one side. It isn't communicated because there was an objection, but it's also put to one side. It's not going to be taken into account. It's just going to be given back to the party that supplied it. So that's where the General Court feels the information is relevant and it shouldn't need to be confidential. All right, that's the exit route there. So it's not disclosed, but it's also not relied upon. It's not taken into account. So if that was your key information for having the listing and it wasn't really something that had to be confidential, but you refused to disclose it, then you're going to lose the case because it's going to be pushed to the side. That's probably not what's going to happen, however. More likely, subparagraph 5, the General Court is going to look at it. What's going to happen if the General Court decides the material is relevant, but it should be confidential? At that moment, it does not communicate the information to the applicant, but it's going to weigh up the requirements for effective judicial protection against the requirements flowing for the security of the Union. So at this point, the General Court has accepted the information is relevant. There's a need for confidentiality. What are we going to do? How are we going to solve this? And the General Court is meant to weigh these up. Once it's weighed it up, it's meant to make a reasoned order. This is para 6. The reasoned order is meant to specify the procedures to be adopted. And there's some illustration of what the General Court might do. They can say, for example, can't you produce a non-confidential version? They can say, can't you produce a summary? Can't you produce material which has got the essential content? I mean, can't you fix the problem somehow, right? By producing something which, all right, isn't the confidential material, but is enough to enable the party to know what the case is. By the way, it's also possible for the defendant to withdraw the material once it gets this decision. And of course, if the material, they say they want to withdraw it, the material is withdrawn and it's not taken into account and it's returned to the party. The real issue is what you think about paragraph 8. I'll read paragraph 8 to you. Where the General Court considers that information or material which, owing to its confidential nature, has not been communicated to the other main party in accordance with the procedures referred to in paragraph 6, that summary and so on, right, is essential in order for it to rule in the case, it may, by way of derogation from another earlier article in the rules of procedure that say you can only base on material that's been shown to the other side, it may, by way of derogation and confining itself to what is strictly necessary, base its judgment on such information or material. When assessing that information or material, the General Court shall take account of the fact that a main party has not been able to make its views on it known. So, in short version, what that says is, when all the tricks for trying to weigh things up and balance it have failed, so when this material is essential and you haven't been able to get round the problem by summarizing it or any of these other techniques, right? The General Court can use that material, even though it's not been shown to the applicant, and it can base its decision on that material, but it's meant to take account of the fact that the applicant hasn't been able to see the material and hasn't therefore been able to make its views known about that material. Now, I'm going to stop at that point and just ask you, by a show of hands, who thinks that's okay and who thinks it's not okay? Those who think it is okay, first of all. Emmanuel, vous devez regarder.
Je regarde.
Voilà. Qui pense que, bon, eu égard à la situation, finalement, ça va, c'est une solution qui tient la route. Donc là, le tribunal peut prendre ces éléments en considération et peut fonder sa décision là-dessus, tout en sachant que la partie requérante n'a pas eu connaissance de ces éléments parce qu'ils sont confidentiels, mais aussi en tenant bien en compte, n'est-ce pas, du fait qu'on sait que la partie requérante n'a pas pu commenter ces éléments. Donc, on doit toujours se souvenir du fait, attention, je n'ai pas les observations de la partie requérante, mais néanmoins, moi, le tribunal, je peux trancher ce litige en me fondant sur ces éléments.
Alors, je vois des mains qui se lèvent, qui considèrent, j'imagine que ça va, sauf si ça signifie que vous voulez intervenir. Donc, Candice Le Charlier, est-ce que vous souhaitiez nous faire part de votre opinion sur ce système?
Bonjour, vous m'entendez?
Oui.
Oui, allez-y.
Donc, c'était plus pour dire que je pense que ça peut être une bonne solution, parce que même si ça pose problème au regard des droits de la défense, ça m'a fait penser à ce que vous disiez tantôt, quand il faut protéger la vie de personnes, enfin l'identité de certaines personnes, qui peut-être que si elles vont être révélées à la partie adverse, ça peut avoir des incidences graves sur la vie de certaines personnes, et que dans ce cas-là, ça doit absolument rester confidentiel, et que si j'ai bien compris ce que vous expliquez, que c'est un matériel vraiment très très important pour que la Cour puisse prendre sa décision. Je pense qu'à ce moment-là, on peut faire une exception, restreindre les droits de la défense si dans la balance, il y a la vie d'autres personnes qui peuvent entrer en jeu. Si c'est une question de vie ou de mort, en fait, pour d'autres personnes.
Je trouve votre réaction est vraiment, je vous remercie pour l'intervention. Je tiens à souligner que dans le règlement de procédure, par contre, il n'y a rien qui limite cette exception au cas où c'est une question de vie ou de mort. Si c'était le cas, n'est-ce pas, les raisons pour plaider en faveur de ce système seraient vraiment, vraiment très, très convaincantes. Parce que justement, comme vous dites à juste titre, question de vie ou de mort, petite limitation aux droits de la défense, la vie ou la mort des personnes, quand même, c'est la vie des personnes, ça a une valeur qui dépasse les valeurs économiques, hein? Mais je tiens tout simplement à souligner qu'il n'y a rien dans le paragraphe 8 de l'article 105 qui limite les pouvoirs du tribunal à considérer qu'il doit procéder à fonder sa décision sur des éléments qui n'ont pas été révélés à la partie requérante au cas où c'est une question de vie ou de mort.
Oui. Ok, alors si je peux me permettre, oui. Alors à ce moment-là, je pense que c'est une solution qui pose problème au regard des droits de la défense, parce que c'est une restriction qui est trop large, je pense.
Voilà, non, mais effectivement, je vous remercie infiniment pour l'intervention, qui est très nuancée et qui effectivement, je me permets de dire, qui montre votre qualité, parce que là, c'est une très bonne intervention. Parce que c'est clair qu'à un moment donné, il faut quand même protéger. Ça, c'est sûr. Mais la question est de savoir, est-ce que la protection que nous trouvons à l'heure actuelle dans l'article 105, est-ce que cela correspond vraiment, est-ce que c'est la bonne solution, la solution qui arrive à faire le bon équilibre entre les droits qui sont en jeu? Mais merci beaucoup pour l'intervention.
Et Eleanor, si je peux, il y a encore deux personnes qui ont demandé la parole, Sarah Albaladejo et puis Elena Placentino. Donc, Sarah.
Moi, j'avais levé la main pour dire que j'étais en fait d'accord pour cette solution. Et pour moi, allez, les questions que je me pose, je comprends que c'est un intérêt, c'est une balance des intérêts. Je comprends que ça peut être problématique. Moi, les questions que je me poserais vis-à-vis de cette mesure, ce serait de voir un peu l'histoire, de voir si c'est utilisé beaucoup, c'est-à-dire de voir si c'est abusé de cette possibilité. Et dans ces cas-là, bah, ce serait en effet problématique. Et oui, je me posais encore une autre question, mais j'ai oublié. Mais en soi, pour dire que pour moi, s'il y a une preuve qui en effet est essentielle, je trouve ça très risqué de devoir l'oublier complètement. Et vu que c'est pas, je pense que ce serait pas qu'un juge, mais plusieurs qui prendraient la décision, j'aurais tendance à croire que voilà, il peut avoir une certaine équilibre entre les juges. Oui, voilà. Donc, la deuxième question que je me posais...
Malheureusement...
Vous entendez, Eleanor?
Je peux crier plus, si vous voulez. Et désolée pour ça. Oui, donc la deuxième question que je me posais... bon, j'ai fini et puis voilà, tant pis. C'était, est-ce qu'il y a un recours possible? Donc, si en effet cette preuve a été considérée comme essentielle et qu'en effet le tribunal s'est basé là-dessus, est-ce que la partie adverse peut contester cette décision du coup?
Eleanor, je voudrais juste vérifier que vous entendez encore ou est-ce qu'il faut qu'on vous réinvite? C'est pas de votre faute. Alors, c'est bizarre, mais je n'arrive pas. Peut-être qu'elle est en train de relancer son ordinateur. Bon, je vais essayer de voir, mais si j'ai pas de message. Hilaria, est-ce que tu peux éventuellement lui envoyer un mail aussi pour qu'on...
Ah, voilà.
Ah,
voilà, je suis là.
Parfait.
We're not having luck today. Donc, si je vous comprends bien, point c'est-à-dire vous faites confiance au juge, mais vous aimeriez ça. Est-ce qu'il y a eu des abus?
Et, et donc, ce qui avait été ajouté quand je pense que vous n'avez pas entendu, c'était de savoir aussi s'il y avait une possibilité de recours contre la décision du tribunal, justement, et donc s'il y avait moyen de revenir là-dessus sans pour autant avoir accès plus au matériel et aux preuves. Et alors, il y avait encore Elena Placentino qui voulait intervenir.
Allez-y.
Elena?
Oui, bonjour. Vous m'entendez bien?
Oui.
Pour l'instant, oui, allez-y.
Pour l'instant, on croise les doigts. Donc, d'abord, mon premier commentaire peut-être rejoint celui que Candice avait fait par rapport au fait que je trouverais ce paragraphe acceptable, surtout dans la mesure où, a priori, le droit à la défense n'est pas un droit absolu. Donc, je rejoins un peu Candice. Mais je me pose aussi une deuxième question, plutôt négative par rapport à ce paragraphe, où en réalité, donc, la procédure, c'est une succession de mise en balance des intérêts, en quelque sorte. Et je me pose la question, cette mise en balance finale ici qu'il y aurait, en quoi est-ce qu'elle se différencie de celle qu'il y aurait eu auparavant? Donc je me dis à la fin, en quoi est-ce que cette dernière mise en balance que la Cour ferait serait plus acceptable pour le suspect que toute celle qu'il y a déjà eu avant? Donc c'est une interrogation.
C'est un commentaire plutôt raisonnable de votre part. I think to try to react to that point, I think it's better than what was there before, in the sense that there is a real recognition that it is necessary to disclose material, and a recognition that you should try very hard to find a way of reconciling the requirements of national security and the rights of the defence. You don't just say, this is rights, this is national security. This is national security. We don't care about the rights of the defence. This is national security, right? You actually have to say, we know it's national security, but there are also the rights of the defence. Because the pre-Cardi, Cardi 1, it's not even reviewable. No, says the court, that's wrong. Cardi 2, well, we're not giving you the material. No, says the court, that's wrong. You have to know the case against you. So it's getting closer to protection of the rights of the defence. But it does, I mean, it does involve really trusting the judges. And also there is no particularly clear guidance as to what's happening when you say, all right, they must bear in mind that the other side hasn't had the opportunity to comment on it. How are they going to bear that in mind exactly? Are they going to ask themselves, what are the questions which, had I been counsel for the applicant, I would have asked of this material? And then when you ask that, you don't have an answer, right? I'm going to go across from there, I mean, because this is a serious issue. By the way, the procedure, as far as I know, but I may be out of date, I do not believe that so far this procedure has really been used. I know the court made immense efforts to try to come up with something, and then they took a decision. The system within the court is called fiducia, and it involves enormously elaborate arrangements, having a room where material is kept safely, having everything, if it's done, if you need to look at that material, there are freestanding computers that are in that room. They're not attached to the computer network of the court. If something has to be translated, it's all, I mean, you know, how elaborate this is unbelievable, right? How much so far has it been used? I don't know. I don't think, to get back to your question about is there any kind of recourse? I mean, yes, in theory, you could say in an appeal to the court, the general court misapplied Article 105 in that they misdirected themselves in law. But your problem is your appeal is going to be an appeal on a point of law. And the general court, unless it's asleep, is going to write its judgment in a way that shows that it followed scrupulously to the letter the wording of Article 105, para 8. So it's going to say, absolutely, we had in mind the requirements of Article 105, para 8, and we bore all of this in mind, and then we reach the conclusion. And that is, I mean, it's the practitioner speaking to you, that is virtually unappealable. How are you going to show that even though the general court said they did that, in fact, they didn't do that, if you don't have access to the material? You know, you're fighting in a dark room with your hands tied. How are you going to contest that? On the other hand, yeah.
If I may, there is just still Clélie Simeoni who wants.
Yes, please go ahead.
Clélie?
Allez-y.
Oui, je me posais juste une question, mais c'est une réflexion, c'est peut-être un peu plus philosophique et un peu moins pratique, mais est-ce que c'est pas aussi important dans ce type d'affaires, quand est en cause la sécurité nationale et quand est en cause le terrorisme, est-ce que c'est pas aussi très important de réaffirmer finalement l'état de droit, et les droits de la défense en font partie? Et est-ce que finalement, au contraire, s'assurer que les droits de la défense sont vraiment respectés et donc que les jugements rendus sont vraiment le résultat du respect de l'état de droit, est-ce que c'est pas aussi particulièrement important dans ce type dans ce type d'affaires. Même si, bien sûr, il y a toujours une mise en balance des intérêts et quand la vie et la mort de certaines personnes sont en jeu, bien sûr qu'il faudra en tenir compte, mais est-ce que c'est pas finalement la réponse d'une société démocratique à des actes contre lesquels on cherche à lutter, quoi.
Ça, c'est absolument le counter-argument, hein, que l'état de droit fait partie intégrale de nos sociétés démocratiques, de nos valeurs, et nos valeurs ne sont pas les mêmes valeurs que les valeurs des terroristes. Hein, est-ce que pour lutter contre, but this is it's part of the wider argument, which is a very important philosophical argument. Are you entitled, for example, in fighting against terrorism, are you entitled to use torture? And the philosophical état de droit argument against that is no, you're not, because the prohibition against torture is a very fundamental and important part of the values which a democratic society that respects fundamental rights and the rule of law will not transgress. So that's the philosophical argument. And there is also usually there is a practical argument and a philosophical argument. That is the philosophical argument. And the practical argument is, you know something, if somebody were pulling my fingernails out, I would tell them anything they wanted to hear so that they would stop the pain. I mean, I really would tell them anything. I would confess to anything. It would be so excruciating. I mean, I'd try to guess what it was they wanted to hear, and then I'd say it. And that kind of evidence, I mean, with great respect, it's worthless. It's not evidence that you should rely on, because the conditions under which it was obtained are such that it is completely untrustworthy. But I mean, but you see, this is where philosophy and practicality meet each other in a really important way. I can make a passionate philosophical argument to you why l'état de droit is important. And then as the practitioner, I can say to you, listen, I want reliable evidence. That evidence will not be reliable. And as soon as the person can, as soon as they're not being tortured and they've been released and they've been to hospital and been treated, right, they will immediately retract all the evidence that they gave. And they will say, that evidence was taken from me under torture. And I retract it. I would never have said it, except they were pulling my fingernails out. So, you know, there's that element in it as well. I'm going to use my final quarter of an hour to tell you a little bit about the special advocate system in the UK, which is a different way of trying to solve the problem. Yeah? Because the problem is not a problem that's unique to the EU. The problem is there in the UK as well. And I gave you in the handout, I gave you, in case you want to read more, I gave you a reference to the 7th report of the Select Committee on Constitutional Affairs in the Parliament, in the House of Commons, which has actually a rather good summary of the special advocate system and what's good about it and what's wrong about it. And that's a good summary. And there is also the first case that came through under the Special Immigration Appeal Commissioner's rules, SIAC, the Reichman case. And I am in the embarrassing position of telling you that I was counsel for the government when it was in front of SIAC, and we lost in front of SIAC, so they sacked me, they got rid of me. And then they went to the Court of Appeal, and then they went to the House of Lords, and eventually they got the result they wanted. So maybe I was a bad advocate, or maybe, which I think is also the case, maybe SIAC was trying to show that they were not a puppet of the government. I think SIAC was really trying to show in that first case that it was independent and that it was going to hold the government and the government lawyers to account. That's a real trailer for reading that case, isn't it? So the way the special advocate system works, it was put in place in response to a decision of the European Court of Human Rights in 1996 in a case called Chahal against the United Kingdom. Mr. Chahal was an Indian national and was a Sikh separatist. And he was, the Home Secretary wanted to get rid of him. And he was saying, if I'm returned to India, I will be tortured because of my non-violent support for Sikh separatism. And one of the things that he was complaining about was that although he had a possibility of judicial review, the actual determination of his risk, whether he constituted a risk to national security in the UK, was made by an internal panel at the Home Office. It was an advisory panel that went under the wonderful name of the Three Wise Men. And the Three Wise Men made that decision on the basis of looking at sensitive intelligence material, which he never got a chance to look at. It wasn't disclosed to him because it was covered by public interest immunity, and he wasn't entitled to any legal representation before the panel. And the European Court of Human Rights said this is a violation of his rights because the review procedure cannot review the grounds for why he was being detained and so on, right? So in response to that, the UK government legislated and put in place an independent judicial tribunal, SIAC, which would hear appeals against these immigration decisions, and put in place the system of having a special advocate. The special advocate is someone who is a barrister, usually, who has security clearance, and who therefore can look at the sensitive material as well as the open material. The way the system works, in essence, is that the special advocate talks to the suspect, the applicant, also has an ordinary advocate, right? So there's the ordinary advocate and the special advocate. And the special advocate can take instructions, just like the ordinary advocate can take instructions from the client. But as soon as the special advocate has seen the closed material, the sensitive material, he may no longer speak to the client because he might disclose something inadvertently. So the way it's been compared to going through a revolving door. Once before you go through the door, you can talk with the client, you can get instructions. Once you've gone through the door, once you've seen the special material, the closed material, you can no longer take instructions. So the special advocate will participate throughout the proceedings, but the moment when the special advocate is obviously vital is when you move across into the closed material, because then the special advocate is asking all the questions, challenging the government on the closed material. But he is doing so on the basis of whatever he knew from the client's instructions and whatever he himself can work out on the basis of being a very clever lawyer. But what he cannot do is to go and ask the client for instructions. Normally, of course, if you're an advocate, you can ask the client for instructions, yes? You say to the client, here is the evidence against you. What do you say about it? And that is what he can't do. So what the special advocate does once he's you know, he can discuss everything that he possibly can with the applicant, and then he takes a deep breath and he takes delivery of the closed material and he looks at the closed material, but that's it. So when he is in the closed section, the closed part of the proceedings, there are really two things that he does. First of all, he argues that some of the material that is in the closed session, in fact, shouldn't be in the closed session. It should be in the open material. And the other thing that he does is that he represents the appellant's interests in relation to the closed material. He does the best he can, but he doesn't have informed instructions. Now, you shouldn't underestimate the importance of the first part, the disclosure function, the part where the special advocate is saying this material shouldn't be in the closed material, it should be in the open material. And I'm going to give you the embarrassing example from the Raymond case. Remember, that was the first ever case, which demonstrates the extent to which the security services can be paranoid. I took disclosure of the material in that case, and as well as a lot of material that was obviously closed material, there was also an extract from a newspaper. And I said to those instructing me, excuse me, this page, this is an extract from a newspaper. Why is this in the closed material? And they said, oh, but you see, it cross refers to this, and then Agent X refers to it. And I said, this is insane. It is a newspaper. Oh, no. Your instructions are it must stay in the closed material. And I said, I want you to record that I said that it should be in the open material, and I foresee that they are going to crucify me. And I was right. All right. They said to me, Miss Sharpston, why is this in the closed material? Because, of course, the special advocate said, it's a newspaper cutting. And I said, my lord, you know, my instructions are, and I gave them the material, gave them what I had been told my instructions were as to why that should not be disclosed. And they just looked at me and they said, that is complete rubbish. That newspaper cutting should have been in the open material. I said, sir, you know, that's what you say, sir. But I think it's fair to say, you see, that this is an important point, and it also highlights for you how difficult all of this is in relation to the rule of law. Because, you know, both the people who are relying on the closed material, the authorities, have to be totally fair. They have to do cards face up on the table. But at the same time, their whole training and their whole business is being secretive. That's what a security service is meant to do. It's meant to be secretive. That's how it succeeds, is by being secretive. And this also draws your attention to the distinction I was making right at the beginning between surveillance and then a decision, and then what you have in court. In terms, and I'm going to finish with, you know, this illustration of the newspaper cutting. In surveillance terms, this was one of the little bits of the mosaic. And it wasn't actually that important in itself, but it gave rise to other measures that were taken, other lines of investigation, which led to a conclusion. And somehow it became part of the closed material. And then once it was in the closed material, because it was all material that was in front of the security service, it sort of became a mindset that it was within the closed material. But it was a newspaper cutting. And as Sayak said to me, what on earth can be secret about a newspaper cutting where the newspaper is on sale throughout the state in question, right? Now, there is no good answer to that. It's a newspaper. Oh, but it was part of the whole story that they... No, that piece of evidence was a newspaper cutting, and it didn't belong in the closed material. It belonged in the open material. It wasn't the only element in the story. It wasn't the pivotal element in the story. It was an element in the story where the call should have been, this is in open material. And it was an error of judgment by the authorities. Arguably, it was also my error of judgment that I let them instruct me to say it should be in the closed material. You know, I tried to make it clear that my view was that it should be open, but maybe I should have just said, listen, I'm not acting if you are saying that's closed material. I don't know. Maybe now, what is it, nearly 20 years on, maybe I would now say to them, this is so ridiculous. I have to tell you, I am not going to represent the Secretary of State if the Secretary of State wants to argue that a newspaper cutting is closed material. You can find another lawyer. I don't know. Maybe now I would, 20 years on, maybe I would say that. That's the ex-Advocate General reprimanding the advocate, right? But it also, I hope that very frank story also shows you the difficulties here. Maybe now I would say, this is, and I would be explaining rule of law and saying, come on, for rule of law reasons, you cannot possibly consider that this is in fact closed material. So I'm going to say, are the questions? I hope I've got you curious enough about the special advocate procedure that you might go and read that extract from the report of the committee, which does explain actually very well the potential unfairness and the contrast with the classic lawyer-client relationship. It is a good, often the House of Commons reports are good. This is a very good analysis, just as a easy way of getting hold of how that procedure works and what's right with it, but also what's wrong with it. Mais est-ce qu'il y a, avant de terminer là, est-ce qu'il y a encore des questions que l'on aimerait poser?
Je regarde. Questions, commentaires? Vous êtes convaincu par le Special Advocate plutôt que par le règlement du tribunal?
C'est une autre solution, hein? Une autre solution imparfaite, je dirais. Mais c'est une solution qui permet quand même d'avancer un peu mieux, n'est-ce pas, les intérêts de la partie requérante. Parce qu'au moins, il y a un avocat là qui a vu quelque chose et qui peut quand même lutter. Et les bons special advocates, ils sont très, très bons. Et eu égard à la tradition du barreau, on peut aussi avoir quelqu'un qui est l'indépendance du barreau, quelqu'un qui a plaidé une fois pour le gouvernement peut, dans une autre affaire, également être special advocate. Hein? Donc, et évidemment, il y a un security clearance pour tout le monde là-dedans. Ça, c'est aussi, c'est clair, hein? Parce qu'on va quand même avoir accès à des documents qui sont vraiment, vraiment confidentiels, des rapports, des notes rédigées par des agents qui travaillent sur le terrain, qui Donc, c'est absolument clair qu'il faut quand même avoir le security clearance requise pour cela.
Mais je pense qu'il reste à laisser digérer toutes ces informations.
Oh, non, il y avait beaucoup, hein. C'est un peu musclé ce qu'il y avait dans le discours d'aujourd'hui.
Et peut-être préciser, parce que je sais qu'il y a une partie des étudiants qui n'avaient pas tout le cycle de vos conférences et de vos cours dans ce cadre de la chaire Francqui, les étudiants du master de spécialisation en droit européen, il y a encore une séance demain matin de 10h à midi, la dernière. Et si vous souhaitez écouter les précédentes, elles sont toutes disponibles via l'enregistrement. Donc, on peut vous transmettre les liens.